Morning, good afternoon, and good evening. Welcome to Course 4A of the Monique and Roland Weil People's Academy of International Law. I am Marjorie Cohn, Dean of the People's Academy and member of the Bureau of the International Association of Democratic Lawyers. Our topic for today is the criminalization of rights and human rights defenders as a means of repression. Our faculty for this course includes Edre Olalia, Charon Usa, Maria LaHood, and Stephen Donziger. Each of them will speak for 30 minutes. Then they will comment on each other's presentations, followed by questions and answers with registrants. We have French, Spanish, and English translation. Please put your questions in the Q&A box for our discussion following the program. In the next few days, we will post the faculty presentations in English, French, and Spanish on our website, peoplesacademy.net. The Declaration on Human Rights Defenders, adopted by consensus in the United Nations General Assembly in 1998, provides as follows: everyone has the right, individually and in association with others, to promote and to strive for the protection and realization of human rights and fundamental freedoms at the national and international levels. The Declaration affirms the core human rights most needed by those who defend human rights. These fundamental human rights, which are set out in international and regional human rights treaties, also form part of customary international law. They include the right to be protected from interference, harassment, and reprisals, freedom of opinion and expression, freedom of assembly and association, the right to take part in the conduct of public affairs, the right to protest, the right to access and communicate with international bodies, the right to access funding, the right to development and discuss new human rights ideas, and the right to a remedy. Treaty bodies report that human rights defenders around the world face abuses, including killings, death threats, enforced disappearances, violence, including sexual violence, public shaming, smear campaigns, and other forms of harassment and intimidation, abductions, arbitrary arrest and detention, torture, baseless and illegitimate criminal charges and arbitrary legal proceedings, defamation campaigns, and misapplication of security measures to target human rights defenders. Restricting the environment in which human rights defenders operate and other tactics to interfere with their work, and attacks on and burglary and unauthorized searches of the homes and offices of human rights defenders. For cooperating with the United Nations on human rights defenders face disbarment, refusal of exit permits, travel bans, imprisonment, assault, threats against their families, intimidation, arrest and torture, enforced disappearance, and even exile and death. Human rights defenders in the occupied Palestinian territory include journalists, lawyers, medical workers, field workers, international volunteers who act as independent observers and carry out human rights work, and defenders working for economic, social, and cultural rights. As of April 26th, at least 800 human rights defenders and international volunteers have been killed in Gaza since October 7th, 2023. Many defenders appear to have been directly targeted. Mary Lawler, the UN Special Rapporteur on the situation of human rights defenders, reported on January 26th. Defenders are in enormous danger, she wrote. Many Palestinian human rights defenders in the occupied West Bank have also been targeted, facing arrests and administrative detention. Within Israel, human rights defenders expressing opposition to the war have also been arrested, she wrote. Our faculty for today's course includes human rights defenders from around the world, from the Philippines to Turkey, to people who defend the rights of Palestinian people and the Amazon communities in Ecuador. Edreyu Olalia is chairperson of the National Union of People's Lawyers, an organization of activist pro bono human rights lawyers in the Philippines. He is transitional president of the International Association of Democratic Lawyers and legal consultant to the National Democratic Front of the Philippines negotiating panel in the peace negotiations with the Philippine government. As an activist and people's lawyer, Edre has practiced pro bono human rights and public interest law for more than 30 years. He served as lead private prosecutor against the general, who is the highest-ranking Filipino military officer ever convicted for the disappearance of student activists. Edre was also lead private counsel in the last-minute reprieve from execution of a trafficked Filipina domestic helper in Indonesia who was framed as a drug mule. Edre has written papers on the peace process, human rights, international humanitarian law, anti-terrorism laws, the right to self-determination and resistance, and people's lawyering. He serves as prosecutor, chief clerk of court, or ponente in international people's tribunals. Edre has been the target of several threats, including vicious red tagging, public vilification, and false charges by the state. Edre will discuss the repression and criminalization of people's lawyers and human rights defenders by the Philippine government. Sharon Usa is a human rights lawyer who formerly practiced in Istanbul, Turkey. In 2016, she moved to Vienna and worked as a guest researcher in the Ludwig Boltzmann Institute for Human Rights for a year. She has been an executive board member of the Progressive Lawyers Association of Turkey, SEASHDE, since 2015, and she coordinates the international committee of the organization. Sharon is the representative of SEASHDE within International Association of Democratic Lawyers and European Democratic Lawyers, AED, and she serves as co-secretary general of the European Association of Lawyers for Democracy and World Human Rights, ELDH. Besides her professional work as Turkey legal advisor of PEN Norway, Sharon is actively involved in the organizing of the annual Day of the Endangered Lawyer and the International Fair Trial Day. Her main focuses are the protection of rights defenders, freedom of expression, and press freedom. Sharon was awarded the Dr. George Leedschak Freedom of Speech Award in December 2016. Sharon will discuss the repression and criminalization of people's lawyers by the Turkish government. Maria Lahoud is Deputy Legal Director at the Center for Constitutional Rights, a New York-based nonprofit which works with communities under threat to fight for justice and liberation through litigation, advocacy, and strategic communications. Maria joined the center in 2003, where she has sought accountability for international law violations and defended Palestinian rights advocates under attack in the United States. She is also a founding board member of Palestine Legal and a member of the task force of the People's Academy of International Law. Maria will discuss attacks on those who advocate for Palestinian human rights in the United States. Stephen Donziger is a lawyer and climate activist who has been the target of an oil company revenge campaign for more than 30 years. In 2013, Stephen helped Amazon communities in Ecuador win the largest environmental judgment in history when a court ordered Chevron to pay $9.5 billion, equivalent to $12 billion today, to restore ancestral lands despoiled by the dumping of billions of gallons of cancer-causing waste. In retaliation, Chevron used its political and financial capital to countersue Stephen for contempt of court, strip him of his law license, and detain him at home and prison for close to 3 years. While Stephen continues the battle against Chevron, he also advocates for other victims of corporate malfeasance and offers legal interpretations of human rights issues. Stephen will discuss the revenge campaign against him by Chevron and its judicial allies. Edre, the floor is yours. Thank you.
Thank you, Marjorie. It's an honor, of course, and a privilege to be part of this tandem. And it's a privilege as well to be co-panelist in the faculty right now. You might have raised too much expectations with the introduction. But anyway, my sharing will focus from the perspective of the Philippine experience, which I would assume would align or intersect or be parallel to the experiences of other peoples and nations all over the world. By way of introduction and context, let me just say at the outset that the Philippines probably has the longest ongoing armed resistance movement, as people residing in its countryside remain mired in abject poverty brought by landlessness, development aggression, and exploitation. Political expression in the country thus ranges from moderate calls for reforms to clamors for fundamental changes in the political economic system. As these calls remain largely unheeded, human rights defenders, like people's lawyers like us, who are ourselves human rights defenders after all, will continue emerging in response to this injustice. When there is exploitation, as in my country, when there is oppression, there will certainly be resistance. And there is a response from the state through repression, and there will be more resistance. By way of sharing on how the law criminalizes human rights defenders as a means of restricting or extinguishing rights, perhaps the Philippines can be considered as a classic case or a laboratory for the weaponization of law, or the what others call lawfare, using the law against the people, because law after all is a weapon to start with, but it's weaponizing the law against the people, against their interests. And by way of a framework, let me revisit what our eminent human rights pioneer, Filipino human rights lawyer said. The law, after all, stripped of its usual rhetorical facade, is merely the collective expression of the interests and a sophisticated mechanism with this language of the dominant elite to perpetuate the existing system in any given society. If you put that in mind, we won't get lost how law is being used and how we can use the law. The use of legal systems and institutions to achieve political and economic objectives will be tackled in my presentation. And in my presentation and sharing, we can see in the concrete how the law is being abused and how the legal processes are being misused to stifle dissent, activism, and even liberation fighters. The abuse and misuse of legal processes have many bad practices in the concrete. For instance, trump up criminal charges. There are still hundreds of political prisoners because the campaign of political repression includes not just violent attacks, but also arresting activists on criminal charges. These are invariably non-bailable charges or offenses and common crimes. Usually, the convenient charges of illegal possession of firearms and explosives, murder, arson, robbery, kidnapping, rarely, if at all, are the activists or revolutionaries charged with political crimes of rebellion, sedition, or insurrection for acts pursuant to one's political beliefs. These charges are made to ensure that arrested human rights defenders remain in jail as interminable court processes take their protracted course. You'll be lucky if you finish a case within 5 years. Hearings drag on with a spectacle of planted evidence and perjured testimonies. In the concrete, the criminalization of rights and human rights defenders are made through secret preliminary investigations. In other jurisdictions, these are called indictment proceedings. False or trump-up charges through legal hocus-pocus or razzle-dazzle and shortcuts are systematically done through trickery, and illegal arrests are made through disingenuous means. From experience, abundant experience, we have seen many ways. For instance, one, through mere substitution of names of generic John Does and Jane Does in the charges with the real names of persecuted individuals. Two, through mere allegation in a police report of the warrants of arrest that person A, for instance, is also person B. Three, through concocted statements of professional witnesses that are filed before or produced even after the filing of previous ones. And we call this remembering by installment because they come up with supplemental statements to cure defects and gaps in the earlier affidavits. 4, through ridiculous assertion that those being charged have unknown address, even if they're publicly known, to prevent them from receiving notice in cases filed in faraway remote places to enable them to defend themselves. And finally, and this is even worse, through mechanical insertion or intercalation of a real name into a list of names of those previously charged. These are the ways, these are the legal tricks in the hornbook of those who want to repress the rights defenders and rights. And of course, there is the filing of retaliatory criminal actions. There's, of course, the SLAPP, no? The strategic legal action against public participation. But in the concrete in the Philippines, part of the harassment and reprisal is to file harassment or nuisance charges against those who speak up, for those who have been acquitted, for those who have questioned certain policies of the military, the police, and even any government agents. There is also the practice of applying for search warrant using fabricated evidence, by planting evidence during service of search warrants, incredible narratives, incredible statement of facts, incredible circumstances that militate against the validity of this search. For instance, in the concrete, before a search warrant is even served officially with witnesses that are required by law, there is already an advanced team of police operatives that barge into a house or an office and plant evidence. And only when they come out will the actual so-called search be commenced. And therefore, it would be shown that the planted evidence have been there all along, unbeknownst to the people who witnessed the actual search. And then, of course, there is the weaponization of counter-terrorism measures through targeted financial sanctions and terrorist designations. You can see on the screen the penal laws, the Anti-Terrorism, the Anti-Money Laundering Act, the Terrorist Financing Prevention and Suppression Act, which are the most commonly used laws being filed against the dissenters and activists. And of course, there are also executive strategies through the creation of this whole of nation approach, creating a supra body of executive body that red tags activists and dissenters. And more than that, it also involves the civilian bureaucracy. So even the Foreign Affairs Department, the local government department, the Securities and Exchange Commission have issued measures that are consistent with these counterterrorism measures. I would like to point out that terrorist designations have been proven to be insurmountable in terms of questioning them through the executive remedies, because the grounds in those executive remedies are illusory, because it assumes at the first instance that the basis for one's terrorist designation is valid in the first place. It doesn't give you any chance to question through an executive manner the listing or the designation of yourself as a terrorist. So the current government maintains the repressive legal infrastructure created by the former administration of Duterte. These include, as already mentioned, the Anti-Terrorism Act, the executive order creating the National Task Force to end local communist conflict. You will be hearing this over and over again. It's called the NTF-LCAC, and various implementing local government and police circulars and resolutions. These are, of course, on top of the terrorist financing prevention and suppression already mentioned, which this present government implements to the hilt. To date, the Human Rights Group Karapatan has so far monitored 91 human rights defenders facing criminal complaints or charges under these laws, while 28 are detained on traffic charges under said laws. Civic space is also being narrowed by increasing requirements, regulations, and restrictions on civil society organizations by the Securities and Exchange Commission and the Departments of Interior and Foreign Affairs, as already mentioned. So-called anti-terrorist financing measures have already been used to arbitrarily harass activists and freeze accounts or assets of civil society organizations. Today, the bank accounts of 12 organizations and 10 human rights defenders have already been frozen, including not just organizational, but even personal accounts. Another form of criminalization is through censorship. The capacity of the state to stifle free speech and expression is not confined to the context of criminal prosecution. Terrorism has served as a convenient concept to delegitimize independent media and call upon regulatory agencies to censor speech outside the ambit of judicial processes. For instance, in the case of bulatlat.com, the longest running online media outfit in the Philippines, a mere letter request from a former national security advisor was enough to prompt the National Telecommunications Commission to order Philippine-based internet service providers to block its websites. There are further reports of continuing attacks against media practitioners, with more than 100 documented incidents of attacks and threats against journalists since the start of the Marcos Jr. administration, including 4 killings in addition to several incidents of harassment, including surveillance, stalking, and accosting of journalists. This is the situation on the ground. In sum, as the recently concluded International People's Tribunal on the Philippines, which we had the privilege of having our dean as an expert witness, found in its verdict on May 18, 2024, just a few days ago in Brussels, excerpts of which I quote extensively with your permission, and I quote, "The evidence showed that the government waged a nationwide campaign of persecution and attacks against individuals and organizations suspected of having links with the National Democratic Front of the Philippines, which is the umbrella underground organization of revolutionary groups. The government formally institutionalized its whole-of-nation approach in counter it and created that body that I mentioned, the LCAC. This body spearheaded an intensified campaign of red tagging or red labeling or terrorist tagging and other forms of disinformation. Such red tagging or terrorist tagging often preceded other, so it's not just red tagging. It often preceded other human rights violations, including extrajudicial killings, enforced disappearance, threats, harassment, and intimidation, trap-up charges, as mentioned, arbitrary arrest and detention. The tribunal further said trap-up charges were filed against NDFP consultants, peace advocates, activists, human rights and environmental defenders, including people's lawyers, humanitarian aid workers, journalists, and members of organizations red tagged as fronts, including our organization, the National Union of People's Lawyers, as the so-called fronts of the Communist Party, the New People's Army, and the National Democratic Front of the Philippines. It goes further. Red tag persons were also subjected to physical attacks by state agents that resulted in deaths or serious injuries. The evidence, according to the panel of jurors, showed that under the Marcos Jr. administration, there has been a steady rise in cases of abduction and enforced disappearance perpetrated by government forces against activists. The victims were taken by force, sometimes in broad daylight, by security forces, held in undisclosed locations, interrogated, and subjected to physical or psychological torture. Some of the victims were later surfaced by the military and falsely presented as New People's Army members who so-called voluntarily surrendered, a claim belied by the evidence which clearly established that the victims were abducted and held under coercive conditions. The tribunal further said the systematic nature of the abductions, the fact that some of the victims were later proven to be in the custody of the military, the lack of any genuine investigation into these cases, and the impunity that characterized these acts all point to the government as the author. The government resorts to terrorist labeling and designations and operationalize the much-assailed Anti-Terrorism Act and other penal laws already mentioned to target civilians, even those engaged in humanitarian work. For now, there are currently 769 political prisoners in the Philippine jails facing charges under terrorism laws and other penal laws, including peace consultants, peace advocates, activists, human rights, and environmental defenders, humanitarian aid workers, and journalists. The use of these laws against individuals and organizations with alleged links to the underground are a component of the overall counterinsurgency strategy that conflates and targets civilians with the combatants and thus forms part of an attack against the civilian population. So what are the impact of this criminalization on civil society? Among others, well, it results in this severe disruption of lives and incalculable damage to rights and freedom. We may acquit them, we may be able to free them in time, but the incalculable damage have already been done if they are lucky enough to survive. It results in the shrinking of civic space and the crippling of civil society organizations that perform humanitarian work. Only recently, a humanitarian organization in the central Philippines was also designated as a terrorist organization and its funds frozen. It also subverts the so-called rule of law. We would rather use the term rule of justice, undermining the credibility and effectiveness of the justice system. And it is an impediment in the long run to peace or the peace process as an alternative path to resolving it. Now, let me go into how the legal and judicial system in the Philippines engenders impunity. There are several factors. One, the framework itself. There is the Philippine government's rehashed counterinsurgency programs patterned or inspired by the U.S. government's dirty wars against liberation movements and groups engaged in resistance, whether armed or underground, or of the legal mass movement. Another factor is the official bias of government. The prevailing government or official mindset or bias against dissent, against activism, against criticism of any kind, and even valid proposals of progressive activists, the militant organizations, and the revolutionary left. They will not have any of it. Another factor will be the wrong, and this is very basic, the wrong or corrupted notion of human rights. This aggravates the mistaken or wrong notion and understanding of the concept of human rights. Who actually guarantees human rights? Who is actually responsible for them? Who can commit human rights violations? You will be surprised that many in government don't even know the answer to these questions. There is also the fact of condonation where high and top-ranking military and police officials that are facing serious and credible charges of violations have been routinely promoted, routinely transferred posts, or even given civilian posts despite opposition from victims, families, and human rights defenders. And finally, and penultimately, rather, the repressive laws and jurisprudence remain in force. You'll be surprised that some dating back to the Marcos Sr. dictatorship and legislative, administrative, and executive and judicial acts that have institutionalized or openly violate human rights, discuss their violations, or merely formally recognize human rights, but in practice actually contribute, ironically, to engenderment of such violations continue. And of course, finally, the circumvention of judicial remedies. We have so much frustrating experience about availing of the remedies of habeas corpus, of the writ of amparo. They have been perfunctorily dismissed on technicalities and even mere denial by state security forces. Karapatan, as observed, these violations occur under a climate of impunity since 2001, and as documented, almost 2,000 extrajudicial killings, more than 200 enforced disappearances, and 1,500 or so torture victims. Yet, a government task force mandated to resolve unsolved cases of political violence, which includes extrajudicial killings, enforced disappearances, torture, and other grave violations, has only handled 385 cases. But they've only garnered 13 convictions in these cases, while perpetrators have been cleared through acquittals and dismissals in 127 other cases. The IPT, the International People's Tribunal of last week, noted that in the cases before them, a recurring fact and common denominator notably runs through all the testimonial and documentary evidence, as well as by responses to the questions of the panel of jurors. And that is the continuing lack of genuine accountability, the brazen impunity of the violations, and the proven general ineffectiveness and inadequacy of domestic remedies that by and large prevent or fail to give justice to the victims. So how can we use international human rights law and mechanisms to stop, prevent, and remedy these abuses? There are many platforms, and Margie has mentioned already the possibilities in terms of the the covenant or the instrument on human rights defenders. By the way, there is a pending bill in the Philippines on human rights defenders, which is being opposed by state security forces, particularly the NTF, because they say with the definition it will include terrorists, criminals, and even outlaws. Now, how can we use human rights law and what mechanisms are there? Well, of course, there is the UN Human Rights Council. I revisited one of our courses rather, Marjorie, on the Human Rights Council and the special mechanisms and special procedures. Of course, it has limitations. We know that. We've been to the Geneva sessions over and over again. There are cluster votings. There are political considerations. There are diplomatic considerations. And the mechanisms have also their own limitations because by and large, they are being ignored or even rebuffed by states who monitor their compliance with certain covenants. And of course, there are also treaty monitoring bodies. No? For instance, the International Covenant on Civil and Political Rights, which is a quasi-judicial body, the Committee Against Torture, and many others. And its limitation, though, is that it has no coercive force to exact compliance with the states. It can only give observations or opinions. And for others, there could be the platform of regional human rights bodies. But as far as the Philippines is concerned, there is no effective and adequate regional human rights body by which victims from the Philippines and anywhere from the ASEAN can run to. And of course, there's also the International Criminal Court. But as you and I know, it has its limitations because the Philippines has already withdrawn. And the only communication that is pending before that court is the crimes against humanity against the former President Duterte in relation to the killings and other violations in the so-called bloody drug war. So perhaps we can explore the avenue or the platform of universal jurisdiction, where in one country one can be prosecuted either criminally or even sued civilly under a national law, even if the act or omission happened in another country. I know for a fact that in the United States there is the Alien Tort Act, by which was used to sue Ferdinand Marcos Jr. for violations of human rights, 3 kinds of violations. And also in Europe, there are other jurisdictions where universal jurisdiction permitted. And finally, of course, the people's tribunals. We will hold our people's tribunals over and over and over again because it has its own value. It can preserve evidence for future use. It memorializes the heroes and martyrs and the victims. It presents an alternative platform and mechanism to prove that seeking justice need not be complicated. Seeking justice need not be tedious, need not be inaccessible. In conclusion, the law can be used against the people, as been shown. But as people's lawyers, we can also use the law to defend our people's rights. We can also use the law to evolve something that is more beneficial to the people. We can use the law for the benefit of the people, but we must go beyond the law. We must use meta-legal tactics. Meta, which is to go beyond the legal parameters by using campaigns, pressure tactics, negotiations, petitions, and so on and so forth. And finally, we should document and preserve evidence because we need something to hold on to when the time comes that we will ask our day in court. And finally, we must develop international solidarity and defense. In conclusion, there is a time for everything, and the time of reckoning will have its own time. Maraming salamat. Thank you very much.
Thank you so much, Edre, for describing the repression by the Philippine government against the Filipino people and the targeting of those who defend their rights and how they fight back. Thank you.
Welcome.
Okay. Sharon, you're next.
Thank you, Marjorie, and thank you, Edre, for the presentation. As we all know, the need to defend and protect human rights defenders is not a new issue. And unfortunately, since 1998, since we have the UN Declaration on Human Rights Defenders, things are not really changing in many countries, such as the Philippines and Turkey. And recently, we observed that the situation is becoming quite same also in Europe. So I think this is a very important topic for our work and for the future. As I said, even though the UN Declaration exists, attacks on human rights defenders continue in Turkey like many other countries. However, these attacks do not stop the defenders, as Edre mentioned. Instead, we adapt to new challenges, often paying a high price both individually and collectively. A lot of human rights defenders from Turkey, they face disbarment, travel bans, imprisonment, assault, threats against their families, intimidation, arrest, torture, enforced disappearance, exile, and even deaths. The criminalization of human rights defenders is a growing international concern, of course. And when we say criminalization, I think we generally refer to the process by which behaviors and individuals are transformed into crimes and criminals. So Turkey is one of the countries countries that have probably more than 100,000 terrorists according to the state. I think the most important question here is about the reason behind this. So why are human rights defenders attacked or criminalized? It's important to understand this reason, and it's important to understand that the reason is not related to the human rights defenders' personal skills, abilities, or their attitude, but this is mostly related to the issues or subjects they defend. I think a striking example of this can be seen in the Palestinian issue currently in many countries. Countries like Germany that claim to be so-called safeguards of rights often unhesitatingly eliminate the right to freedom of expression, right to security, blacklisting human rights defenders, even the ones who make just simple statements in favor of Palestine. And in Turkey, the situation concerning the Palestinian issue is slightly okay, but when it comes to the Kurdish issue, everything changes. Almost all human rights defenders who oppose the denial and destruction of the Kurdish people, expose state crimes, or advocate for Kurdish independence and their cultural rights are at risk. One of the most important examples is the case of Şebnem Korur Fincancı, who is an internationally well-known forensic scientist and also the chairperson of the Turkey's Medical Association. She was tried several times because of different reasons. However, her latest arrest was a result of a live interview she gave on a Kurdish TV channel. She commented on the footage related to Turkey's cross-border operation in northern Iraq. She highlighted the possibility of chemical weapons being used and called for an independent investigation commission which should investigate the possible crimes that Turkey committed. And because of this statement, she was accused of making terrorist propaganda. Another example of how the Kurdish issue and calls for peace can quickly become criminalized in Turkey is the case of the 1,128 academics, again including Fincancı. They are known as Academics for Peace. These academics issued a statement in 2016 protesting the curfews imposed in several cities in Turkey's Kurdistan without any legal basis. When the statement was published, at the time, dozens of Kurds, including many children, had lost their lives due to these curfews because of the state forces operations. The statement reminded the government of its obligations and called for an end to the military operations. And as a result, all 1,128 academics faced criminal prosecution. During the state of emergency declared in 2016, after this statement, I think 6 months after this statement, they were also dismissed from their universities, and some of them are still live as refugees or exiles in different countries. These two limited examples show how human rights defenders face terrorism charges when it comes to the Kurdish issue automatically. Essentially, even though human rights defenders pay a price, I think this part is important, the main target of these attacks is to prevent the support and defense of the Kurdish people. Therefore, any attack on human rights defenders cannot be seen as limited to them alone. Moreover, I believe that the most effective way to defend the human rights defenders is not just to support them as individuals or groups, but to also highlight the rights they are defending. And in Turkey, the methods can change over time. Like in the 90s, torture, forced disappearances, and murders were most common methods. Today, these methods are used less frequently, but they have not disappeared, of course, completely. For example, next June, we will have one trial, which is very important for us. the president of the Ahmet Bar Association, the Diyarbakır Bar Association, Tahir Elçi, was killed in 2015 while he was making a press statement. And the case is still going on, and the case probably end in impunity next month. And it will be a setting, like it will set the stage for future massacres. And last week, Kurdish politicians and human rights defenders received prison sentences ranging from 20 years to 40 years in a trial known as Kobani case in public. Although the case was opened on charges of membership in a terrorist organization and of attempting to overthrow the state and government, the basis for these charges were their public statements, their participation in marches, and some sort of other legal activities. So in Turkey, I try to put together what kind of common methods the state is using against human rights defenders, and I think we have like four main titles here. Like one is the basis charges, arbitrary detention, basis convictions, as Edre mentioned. There are several examples, but I will try to focus on the situation of lawyers. As I mentioned, in 2016, a state of emergency was announced, and following that announcement, security forces engaged in widespread arrests, which continue to be made also today. Journalists, academics, human rights activists, politicians, judges, prosecutors in opposition who are critical of the regime have been severely affected in this wave of arrests. And of course, lawyers have also been targets. According to a report published by Human Rights Watch in 2019, the number of the lawyers who have been prosecuted was 1,546. And at the time, 274 were convicted, and around 600 of them were in pre-trial detention. And probably today the number is higher than this, but unfortunately we do not have a very concrete report about it. But the state, as I mentioned, this state of repression and legal insecurity is not unfamiliar to human rights lawyers in Turkey. And at the time also, this was not something new. Over the last decades, lawyers from Turkey have been put on trial frequently, facing accusations relating to terrorism. They have also endured long-term arrests. For instance, in November 2011, 45 lawyers were put on trial, accused of membership of a terrorist organization because they were representing Abdullah. This was the only reason of this case, and this case is still going on. I think it's the 13th years of the case. And in 2013, January, a mass police operation was carried out against the Progressive Lawyers Association, which is my association. 22 lawyers were put on trial, again with the accusation of membership of a terrorist organization, and they were detained for periods between 9 and 14 months. And in 2017, after the state of emergency, I hope that this will give the idea about the continuity. Another trial started against the Progressive Lawyers Association, and the legal process was very complicated. Those cases were merged, and there were the same defendants were accused in the same in two different cases. The evidence, so-called evidence, were the same. But in the end, many of them were convicted, and significant of them are still in prison, including the president of the Progressive Lawyers Association, Selçuk Kozağaç. Today, still this tendency is going on. The only difference is that in the past, the cases were going on for years, but now there is the tendency to finalize trials as soon as possible, and the gravity of the punishment is also incomparable to past ones. And the most up-to-date example is the case of lawyers Betül Kozağaç, who is also an executive board member of the Progressive Lawyers Association, together with two of our other members, Seda Şaraldi and Didem Baydar Ünsal. They were also arrested simply for representing a person who was part of an armed attack against police officers in February 2024. There were no link between lawyers and the person except the power of attorney. And our colleagues are still in prison, and there is no indictment, and we have no idea when the trial will start. So such criminal prosecutions are one of the main method that the state is using against the human rights defenders, including lawyers. But another issue is, I think, related to the judicial system itself. Normally, I would like to say that the weak judicial system can affect the work of human rights defenders, but in Turkey's case, we are calling it as no judicial system. because after the state of emergency, again, very after it, like a couple of days later, the state announced series of governmental decrees, and they dismissed more than 3,000 judges and prosecutors from their duty, and more than 2,000 of them were arrested. And of course, this creates a very strong fear within the so-called free members of the judiciary. They are very aware that if they will make a decision, make a judgment which is not in favor of the government, they will be under the risk of harassment, or they will simply lose their position, or they will just be appointed to a lower court. And we have one concrete example. The case that I mentioned about the Progressive Lawyers Association, the second case, after a year of pretrial detention, all the lawyers were released, and the judgment concerning their release was very strong. It was mentioning the judgments from Strasbourg, from the European Court of Human Rights, and it was also saying that these people are lawyers. They don't need to be under pretrial detention. But in 24 hours, the same judges reversed their own judgments, and all the colleagues were arrested one day later again. And those judges who released the lawyers in the first place, they were appointed to other courts, which were not the criminal courts. So this was like they were not arrested at the time, but they were just punished. So this is also affecting everything. And I also need to mention one other issue about the judiciary itself. Maybe you heard about Ebru Tim, a Kurdish female lawyer who went on a 238-day hunger strike for fair trial rights, highlighting these judicial flaws that we are discussing here. And she said that she is not doing this only for herself or only for the other lawyers who were defendants, like her co-defendants in the same case, but she said that she is doing it for all the other political prisoners in Turkey who are wrongly accused and who are under pretrial detention or wrongly convicted. And unfortunately, she passed away in August 2020. We organized a very strong campaign to support her cause, but unfortunately, it was not enough to save her life. However, international legal community, including ELDH, IADL, and many others, establish an annual day, which is the International Fair Trial Day. Every year, the day is focusing on one specific country, and on the 14th of June, a central event is organized to highlight the fair trial issues in the respective country. Also, the Ebru Timtik Award was recognized, and this award is given to one person or a group from the focus country who makes contributions to the fair trial rights struggle. So at least we have a new tool to resist against all this arbitrary situation. Another issue is the interpretation of the existing laws. For instance, the anti-terror law of Turkey. We have one, I will just give one example from this law. We have one simple article, Article 5, and this article was there for years, but it was never used before. And in the recent years, now this article is frequently used against the journalists and the human rights defenders. The article is about making the public officers target to the terrorist organizations. And now, when a journalist, especially the court reporter, write a report about one well-known court and mention the name of the judge, which is publicly known, which is normally published online, and they're appointed, like everybody knows which judge is following which case, they can be accused with this article. And before there were no arrests, but recently they also started to arrest journalists because of this. And this is, I think, a very strong example how the law can be misinterpreted like in favor of the state power, and how this can turn into a tool against the human rights and human rights defenders. And of course, like many other countries, in Turkey, we also have the problem of stigmatization, especially the trials that we are talking about. They are, on the one hand, becoming a tool of this stigmatization. In 2013, when the police operation happened against Progressive Lawyers Association, for instance, for a month, every news were reporting that in our Istanbul branch, like in our building, they were saying that we had 13 steel doors, but our office was just like 35 square meter place, because we were not a rich organization. We never had a chance to have a huge place which can have 13 doors. But many people believe this. And they were talking about cosmic rooms that we were using to communicate to each other, but we were just using our phones like all the other people. So of course, some people believe this, but one of the most interesting example of this happened in 2014. We were in Soma, a small town in Turkey, which is known as the town of miners. And there was a so-called work accident in the city, and 301 miners lost their lives in this accident. And the next day, we moved to that, we traveled to this city because we were very aware that if we cannot go there on time, then the state officials will start to visit all the families and will force or will manipulate the families of the miners who were killed to sign some documents which will mean impunity for the future. So the first day we were almost attacked by the public, because the public was told by the secret police forces that we were there just to start a new uprising against the state. And this didn't work. In 3-4 days, we had the chance to establish a very strong relationship with the people, because they understood that we were there to support them, etc. So the state understood that their tactic didn't work, and we were arrested 4 days later. So, they first tried to stigmatize us, and they first tried to manipulate the public, and when it didn't work, then they decided to arrest us. This year is the 50-year anniversary of my association, Progressive Lawyers Association. The association was established in 1974 by the lawyers who were defending 3 persons who were coming from the student movement, but then became a part of a Marxist organization, and they were executed in the end. And the lawyers who were defending them, they established the association. And the first status and the first declaration was saying that the aim of this organization is ensuring and protecting the human rights, but also people, because we are the people's lawyers, and also workers, because we are taking a position in favor of labor. And of course, when the first coup happened in Turkey, when the most important coup happened in Turkey in 80s, our association was banned and many of our members were arrested. And in the beginning of 90s, the association re-established, and in 2 months it was closed again, because the association declared its support to a very strong march which was started again by the miners in Turkey, and they re-established it. And in the 90s we lost a lot of members. They were killed by police, and they were kidnapped, and they were tortured, but the association remained open and active until 2017. After the state of emergency, we were closed again. But this time we announced that we will break the seals, and we really did it. And we said that we will not try to re-establish ourselves, but we will keep our offices open, and we will do whatever we are doing in general. And we had a very strong public support. After the removal of the state of emergency, finally we could re-establish, and this year we are celebrating our anniversary. I mention this because I think time to time in some countries, the history of human rights defenders or their collective organizations can be also read as the history of the social movements and social struggle, and also state repression. And I think our histories can be modestly accepted as one of the examples. And I just want to say that, even though things are complicated in Turkey, in the Philippines, as Edra mentioned, it's also important to see that the resistance is still going on, and there is no gap between the years, even though the repression is time to time unbearable. So if we want to protect human rights defenders, and if we really want to support their work, I think the most important thing is supporting the cause that they are defending, the people that they are defending, or the issue that they are defending. Without defending the rights of Kurdish people, you cannot protect the human rights defenders in Turkey. Without defending the rights of workers, you cannot protect the human rights lawyers or trade unions who are working for them. So I think this is the key point. And I believe that at one point, with the international solidarity and also with the domestic resistance, with ongoing struggle, at one point we will have the chance to discuss more hopeful issues. Yeah, thank you.
Thank you so much, Sharon, for explaining how and why the human rights of the Turkish people and indeed people's lawyers are under attack by the government and the ongoing resistance. Thank you so much for that. Next up is Maria.
Thanks, Marjorie. It's an honor to be here with the People's Academy of International Law and my co-panelists, and to be joined by people from all over the world. I'm going to focus on the suppression of human rights advocacy in the United States, but want to first discuss U.S. human rights defenders who were deliberately killed by Israel, and how the U.S. not only failed to investigate or hold Israel accountable, but when their families sought justice and accountability in U.S. courts, the U.S. government intervened to protect Israel against them. More than 20 years ago, Rachel Corrie was run over by an Israeli soldier driving a militarized Caterpillar bulldozer as she stood in front of a Palestinian family's home in Rafah, protecting it from demolition while they were inside. We brought a case against Caterpillar on behalf of Rachel's parents and 4 Palestinian families whose family members were in their homes when they were demolished on top of them. CCR pioneered the use of the Alien Tort Statute to bring international human rights claims in U.S. courts that Adre mentioned. So we argued that Caterpillar violated international law by aiding and abetting Israel's war crimes by selling D9 bulldozers to the Israeli Defense Forces, knowing they would be used to unlawfully demolish homes in occupied Palestine. The U.S. government submitted a brief asserting that it paid for the bulldozers at issue, so holding Caterpillar accountable would interfere with U.S. foreign policy, so the court dismissed the case. In 2010, 18-year-old U.S. citizen Furkan Doğan was on a humanitarian flotilla taking aid to Gaza when Israeli commandos shot him 4 times. And while he lay wounded, they shot him in his head at point-blank range. His family brought a case in federal court against Ehud Barak, and Israel asked the U.S. government to suggest immunity. So the U.S. government came in and said Barak should be immune, and the case was dismissed, cementing impunity. 2 years ago, an Israeli marksman shot to kill world-renowned Palestinian-American journalist Shireen Abu Akleh, who bore witness to the oppression of Palestinians and their resistance and shared it with the world. And then the marksman shot at those who tried to help her as she lay on the ground. Days later, Israel attacked her funeral. The Human Rights and Special Prosecution section of the U.S. Department of Justice, which has jurisdiction to investigate and prosecute war crimes as well as genocide and torture, has opened a criminal investigation into her killing. This is progress, but it has now been 2 years since Shireen was killed. Meanwhile, the Department of Justice quickly brought war crimes charges against 4 Russian soldiers for war crimes in Ukraine. These cases have helped cement the impunity that has permitted Israel's U.S.-backed genocide that has killed 35,000 Palestinians, 15,000 of whom are children, and is intentionally starving an entire people to death. As protests against U.S. complicity in Israel's genocide have proliferated in the U.S. and the movement for Palestinian freedom continues to grow, so has the suppression against them. Since October, there have been thousands of incidents of suppression in the U.S. At work, people are being silenced, disciplined, retaliated against for advocating for justice for Palestinians, and more than 160 people have been fired from their jobs for speaking out. And that's what we know of. Some are just leaving. The FBI has increased its surveillance and questioning of pro-Palestinian activists. Just recently, Israeli historian Ilan Pappé was interrogated coming into the United States about whether he supports Hamas and whether he believed Israel was committing genocide. On college campuses, students are being disciplined, doxxed, suspended, banned, expelled, arrested, beaten, and silenced, often by false accusations of anti-Semitism for criticizing Israel, or supporting terrorism for advocating for Palestinian rights. We've been defending Palestinian rights activists for 13 years, and the scale of the current repression is unprecedented. Students have been inspirational. They are organizing, protesting, erecting encampments on over 180 college campuses across the US, demanding an end to Israel's genocide of Palestinians and US complicity in it, including by their universities. But the student protests have been met with violent attacks by militarized police and college security officers called in by their own universities. There have been more than 3,000 arrests related to the encampments, and many students were suspended and lost their housing as well. At the University of California, Los Angeles, a mob of white nationalists assaulted students for hours, while police stood by and watched, sending at least 25 students to the hospital. None of the assailants were arrested, but the next day, students and faculty at the encampment were arrested. The response by police, some trained by Israel, is to violently protect white supremacy, US imperialism, colonization, the elite class, the arms industry, the fact that might makes right, and they are defending it against the power of people to dissent and demand that human rights be upheld. International law and mechanisms can be used as a tool to build power, to fight for justice, and to help shift the narrative. The UN Special Rapporteur on the Right to Education, Farida Shahid, recently did a country visit to the US and said that one of her biggest concerns during this visit is the increasing attacks on peaceful student protests across the country. The most appalling factor is the unequal treatment of protesters, depending on their political position. Pro-Palestinian protesters are disproportionately affected by the harsh response, allegedly for their anti-Semitic views. Paradoxically, even if they self-identify as belonging to the Jewish community or represent Jewish student associations. Yesterday, CCR signed on to a letter initiated by National Students for Justice in Palestine and other student groups in the US, along with Movement Lab, to 12 special rapporteurs and independent experts and 2 working groups regarding the widespread and systematic violation of rights in the context of the student protests across the US. We've discussed it at other People's Law Academy programs, but in case people aren't familiar, there are a number of Human Rights Council's special procedures mandate holders, which are either country-specific or thematic, including freedom of opinion and expression, freedom of peaceful assembly and association, for human rights defenders, against racism, on human rights in the occupied Palestinian territory, and many more that are relevant here. And these special procedures write reports, conduct studies, do country visits, send communications to states, help develop international human rights standards, engage in advocacy, issue statements, and help raise public awareness. Engaging with them can be an effective advocacy tool for movements and people most impacted by human rights violations. Then they report at least once a year to the Human Rights Council on their findings and recommendations, as well as the UN General Assembly. I think the letter that we sent is being shared, and if groups are interested in endorsing, they're still accepting endorsers. Another way we've engaged with UN mechanisms around this issue and others is when the US government has been reviewed by UN treaty bodies, including compliance with the International Covenant on Civil and Political Rights and the Convention on the Elimination of All Forms of Racism. Working with international law and mechanisms can help expose violations and put pressure on governments. And here, in this case, can be used as counter-pressure to the immense pressure that universities are facing to crack down on student support for Palestine, from donors, from Congress, from Title VI civil rights administrative complaints, from lawsuits, and from false accusations of anti-Semitism or support for terrorism, and to counter the rampant anti-Palestinian racism. This morning, 3 more university presidents, including UCLA's, are testifying before the McCarthyite U.S. House Education and Workforce Committee for the 3rd hearing of its kind, entitled Calling for Accountability, Stopping Anti-Semitic College Chaos, in which right-wing members of Congress, who couldn't care less about real anti-Semitism, conflate it with advocacy for Palestinian rights in order to permit Israel's genocide to continue. The prior 2 hearings resulted in the resignations of the presidents of Harvard and University of Pennsylvania, and likely led to Columbia's president calling in the New York Police Department to sweep Columbia's student encampment. There are currently several cases and administrative complaints against university claiming discrimination against in a hostile environment for Jewish students. Title VI of the Civil Rights Act of 1964 prohibits discrimination based on race, color, or national origin by any program receiving federal funding. Starting 20 years ago, there were efforts by Israeli apologists to have that cover anti-Semitism, and more recently to include Palestinian rights advocacy as anti-Semitic, including to get the Department of Education Office of Civil Rights to codify the International Holocaust Remembrance Alliance definition of anti-Semitism, which essentially redefines anti-Semitism to include criticism of Israel. So far, that definition has not been codified by the office. The number of Title VI complaints claiming hostile environments for Jewish students have ballooned, but so have complaints based on anti-Palestinian racism and discrimination against Arabs and Muslims, and allied students as well. And the US Office for Civil Rights has also initiated investigations into several colleges or universities for that discrimination. So students are fighting back with affirmative cases, fighting against the suppression and the banning of their organizing as well. The Anti-Defamation League called on university presidents to investigate Students for Justice in Palestine chapters for material support for terrorism. And Florida Governor Ron DeSantis used the same rationale to order a ban of SJPs from the state's public universities. SJPs sued, and the judge dismissed the case, finding it unlikely the university would actually follow through with the ban, but recognized it would likely violate the First Amendment if they did. Students for Justice in Palestine and Jewish Voice for Peace have sued Columbia for banning them under New York law that allows you to challenge decisions by private institutions that are arbitrary or go against their own guidelines. We brought a similar case against Fordham years ago. There's also another case for defamation and privacy violations against Accuracy in Media, who sent mobile billboard trucks displaying student photographs or their names under the headline "Columbia's Leading Anti-Semites" to drive around students' campuses and homes. Israel has been building the infrastructure for these suppression efforts for years. In 2017, the Israeli Ministry of Strategic Affairs set aside $72 million to fight against what it called the delegitimization of Israel and set out its plans to establish and fund what it calls an international legal network to stop the global movement for Palestinian freedom. Israel has contracted with the International Legal Forum, an Israel-based NGO and global network of groups fighting BDS in 40 countries around the world, to administer grants to network members. It's important to remember that BDS is a call from Palestinian society to boycott, divest, and sanction Israel until it complies with international law. Advocates have long been using international law to support their calls for freedom, justice, and accountability. Israel fears the power of the people to isolate it and to enforce international law against it. Going back to 2011, CCR represented Olympia Food Co-op board members who were sued for passing a boycott of Israeli goods, a case that Stand With Us, one of the many groups that suppress criticism of Israel, was behind in partnership with the Israeli Ministry of Foreign Affairs. This is a local food co-op that decided not to carry items from Israel, and Israel got involved to stop it. It took 9 years to get the case dismissed. It went up to the Washington State Supreme Court and back. We originally brought an anti-SLAPP motion, which Adre had mentioned, and I'll describe in a minute, and it went through discovery. Documents came out showing the plaintiffs celebrating that the case had discouraged other co-ops from boycotting Israel. The purpose of these cases is to chill advocacy for Palestinian rights. CCR is still defending a similar case brought by the Brandeis Center and the Deborah Project against the American Studies Association and several individuals, including Stephen Salaita, who we represent, in response to a 2013 resolution that the ASA passed endorsing the call to boycott Israeli academic institutions. That was 11 years ago, and litigation is still ongoing. The federal case was dismissed after 3 years, so plaintiffs sued in DC Superior Court, and we and other defense counsel brought anti-SLAPP motions, which eventually we won. A SLAPP, as Adre said, is a strategic lawsuit against public participation. And more than 30 states and DC have anti-SLAPP laws to deter the abusive use of courts to chill free speech. The laws are supposed to make it quicker to dismiss meritless claims that target protected speech and generally require plaintiffs to pay attorney's fees if they lose, so there can be a strong deterrent. So we won our anti-SLAPP motions in that case, and they're currently on appeal. Another front for assaults on BDS has been legislation. Most states in the United States have passed anti-BDS laws targeting advocacy for Palestinian rights. Many of the laws establish a blacklist of entities that boycott Israel and prevent the state from investing in them or contracting with them, and some require public contractors to certify that they won't boycott Israel. Netanyahu has said that Israel has promoted these laws in the US. At one point, the American Jewish Committee got all 50 governors to join its Governors Against BDS campaign, condemning BDS and supporting Israel. Some of these laws have been challenged, most of which have succeeded, but the Eighth Circuit Court of Appeals ruled that boycotting Israel is not protected by the First Amendment because it's non-expressive commercial conduct rather than protected expressive conduct. So that fight is ongoing. As others mentioned, accusations of terrorism have also been used to suppress advocacy here for Palestinian liberation. CCR and Palestine Legal recently published a report, Anti-Palestinian at the Core, showing how opposition to Palestinian rights by Israel-aligned groups helped craft US federal anti-terrorism law from the start. The first mention of terrorism in a federal statute in the US was in 1969 and dealt specifically with restricting humanitarian aid to Palestinians. The first terrorism blacklist was championed by Israel supporters and has been used to pressure governments accused of supporting Palestinian resistance. The first law permitting private lawsuits around terrorism was drafted to target the PLO. And the first financial sanctions terrorist blacklist was created in response to Israel demands to crack down on Hamas and other Palestinian factions. There's been civil litigation. We recently won a case brought by the Jewish National Fund against the U.S. Campaign for Palestinian Rights, which is one of the oldest Palestine solidarity organizations in the U.S. under the Anti-Terrorism Act, which permits U.S. nationals injured by an act of international terrorism to bring civil suits in federal court. The International Legal Forum that I previously mentioned claimed credit for bringing the case. The JNF alleged that U.S. campaign was liable for damage to land caused by incendiary kites and balloons launched from Gaza into Israel during the Great Return March, because the U.S. campaign had expressed support for Palestinians' right to protest and demand their right to return without being shot at by Israel, and because it served for a time as the U.S. fiscal sponsor for the Boycott National Committee. And one of the BNC members is another coalition made of Palestinian parties, one of which is Hamas. The court dismissed the complaint as meritless. Now the ILF, the International Legal Forum, and the National Jewish Advocacy Center has brought a case against UNRWA USA under the Anti-Terrorism Act because of its support for UNRWA, the UN agency, on behalf of victims of October 7th. Some of the same plaintiffs sued the Associated Press, claiming that their payment to a photojournalist for the real-time images of Israeli hostages being taken into Gaza supported terrorism. Those are two of a handful of cases that have been brought under the Anti-Terrorism Act related to October 7th. We also expect we could be seeing criminal prosecutions. 15 years ago, the Holy Land Five were convicted for material support for donating to Palestinian charities that the U.S. government itself supported. 3 of the 5 are still in prison. There have also been various legislative attacks. A bill was passed by the House that, if enacted into law, would empower a single government bureaucrat to revoke the nonprofit status of any organization they deem to be supporting terror. And this week, after the ICC prosecutor announced he's seeking arrest warrants against Netanyahu and for war crimes and crimes against humanity, including extermination, the Biden administration said it will work with Congress on an appropriate response, following threats by members of Congress to sanction ICC employees and prevent them and their families from coming to the U.S. Previously, when the former ICC prosecutor had requested a determination on the ICC's jurisdiction over the Palestine situation and had advanced an investigation into crimes committed in Afghanistan, including into the U.S. torture program, the Trump administration imposed sanctions on the ICC prosecutor and another senior official and banned them from entry. The Biden administration lifted those sanctions and later applauded the ICC's issuance of an arrest warrant for Russian President Putin for war crimes. About 6 months after Biden rescinded Trump's order sanctioning ICC officials, Israel designated 6 Palestinian human rights groups as terrorist organizations, and then raided their office and issued order for them to cease work, trying to intimidate and isolate them and cut off their funding. One of the designations explicitly mentioned the promotion of steps against Israel in the international arena, referring to their work in the ICC. Several of the groups were involved in submissions to the ICC seeking accountability. These attacks all share the same objective: to try to eliminate support for Palestinians in an effort to isolate and eliminate them, to distract from Israel's violations, and to win a narrative war. Rather than stop being a settler colonial apartheid and genocidal state, Israel and its apologists instead try to stop people from criticizing it or from supporting Palestinians. These attacks in the US are an extension of Israel's oppression of Palestinians living under occupation, under siege, under apartheid, and under attack. They are attacking those standing up for Palestinian rights wherever they are. But suppression works by creating a climate of fear. The biggest problem is the chill, the widespread impact that goes beyond the individuals targeted. So the important thing here is not to be silenced, not to be chilled, and not to be distracted. Use the assaults as opportunities to discuss the real issues, not just the free speech principles, but the underlying human rights issues about Palestinian freedom and about Israel's genocide of Palestinians in Gaza and U.S. complicity. The movement to liberate Palestine will not be stopped. Thank you.
Thank you, Maria, for detailing what's happening in Palestine with Israel's genocide, the U.S. support for that genocide, and the targeting of human rights defenders in Palestine and in the United States for protecting the human rights of the Palestinian people and the legal tools to resist that repression. Thanks so much. Next, we have Stephen Donziger. Stephen?
Thank you. And thank you to my fellow panelists for excellent presentations. I'm in solidarity with each of you, and I particularly want to thank, before I get into my analysis, Maria and the folks at the Center for Constitutional Rights, you, Marjorie, and the International Association of Democratic Lawyers, the National Lawyers Guild. These are U.S., well, two of them, but the three are US-based organizations that have advocated for human rights for people like me. I'm a frontline lawyer fighting the oil industry for decades and decades. I'm inspired by your work, and I also want to thank you for your solidarity, both to me and the Amazon communities in Ecuador that I represent. So thank you, thank you, thank you. And Maria, your presentation about repression in the United States was just dead on, and I really appreciate the work that went into sort of organizing all of that information. I'm going to talk very briefly about what happened to me personally, and then I'm going to talk very briefly about my analysis of what happened to me and how that fits into the broader context of the topic we're discussing today, which is the criminalization of human rights and repression of human rights defenders. A lot of people out there on this call around the world, I mean, obviously the United States is the United States. And as Maria just pointed out, our country is not exactly the greatest adherent to international law in the world. But I will say a lot of people don't fully understand that domestically, within the borders of the United States, people who engage in traditional activities that challenge entrenched interests of power are often imprisoned or hit really hard, even though the mythology of this country is always trying to project that within our country, problems that exist in many other countries, like the problems in Turkey, for example, that were explained by Seren, don't really happen here. And I want to acknowledge that there are other places in the world where these acts of repression, imprisonment, murder, political murder, assassination happen to a much greater extent than here. Those types of kind of authoritarian generated, acts of repression, weaponization of law, changing laws in midstream to try to, stop someone from speaking out or stop someone from advocating are happening more and more in the United States. What we are seeing in other countries historically is happening more and more here. In my particular case, I spent many years, I live in New York City. I live in my apartment where I'm located right now speaking to you. I spent many years representing communities in Ecuador in the Amazon fighting Chevron. And I took, by the way, over 250 trips down to Ecuador from New York. I never actually lived there. We had an Ecuadorian legal team. And over a period of many years, we ended up through a lot of hard work and marshaling of very important evidence of pollution. We ended up winning roughly a $10 billion pollution judgment against Chevron. Rather than pay the judgment in the jurisdiction where Chevron had wanted the trial to be held, Chevron then sued me back here in the United States. And I know the first speaker from the Philippines talked about how law is weaponized. Well, that's what Chevron did to me here. They sued me for $60 billion US. I got sued for the most amount of money any individual in the history of this country, as far as I know. I haven't seen any other person get sued for more money than what they sued me for. And this was obviously an effort to try to intimidate me into stopping my advocacy and also intimidate other lawyers and other campaigners from helping the Ecuadorian communities. And over time, over many years, they kept throwing these lawsuits at me. And ultimately, to make a very long story short, we kept going after Chevron's assets to force the company to comply with the Ecuador judgment. And we had filed lawsuits in other countries, including Canada, Argentina, Brazil, to execute on the judgment in Ecuador that Chevron refused to pay. By the way, Chevron pulled all its assets out of Ecuador, and there was nothing to collect in Ecuador proper. because I was the person organizing the financing. I was raising donations and investment money to fund the litigation. And because I was the person doing the traveling and explaining to lawyers in these other countries, the history of the case and really driving a lot of this activity, Chevron concocted this scheme I was in Canada at the time, and they had a judge here issue an order that I turn over my computer and confidential case file to Chevron in the context of a civil litigation. And that would have required me to violate my duties to my clients in Ecuador. It would have probably have put their lives in danger because there was so much confidential information, but it really was just a way to harass me. So when I appealed this order, this blatantly illegal, unconstitutional order, by the way, I've never heard of another lawyer being ordered to turn over his or her case file in the middle of a civil litigation to adversary counsel. That had never happened before. So when I appealed the order, the judge charged me with a crime. He charged me with criminal contempt of court for appealing and, for not complying with an order that I had appealed while it was pending appeal. And much to my shock, he then had me locked up on house arrest pending trial. And the actual charge was the lowest level federal criminal offense. It was called a misdemeanor with a maximum sentence of 6 months in prison. There had never been a lawyer in the history of this country who had been locked up prior to trial on a misdemeanor contempt of court charge. Even worse, the judge, in our system of separation of powers, the judges don't charge crime in the United States. The executive branch, that is, prosecutors, charge crime. However, judges can charge contempt of court if a lawyer disobeys them within the context of the courtroom or a particular case. And the judge used this little exception to the general rule that judges can't charge crime to charge me with a crime. But then he was required to take it to the professional prosecutor here in New York, federal prosecutor, who operates under the executive branch. And the prosecutor saw the charges, rejected them, and refused to prosecute me. At that point, the judge did something I've never seen before, not only in the United States, but in any other country in the world. He actually appointed Chevron, a Chevron lawyer, to prosecute me in the name of the US government. That is, the professional prosecutor rejected the case, so the judge appointed Chevron to prosecute me and to detain me, which is why I believe I ended up detained for almost 3 years in my home and 6 weeks in a federal prison for a crime I didn't commit. And even if I had committed it, no lawyer has ever even served a day in detention for this misdemeanor contempt charge, other than me, who served almost 3 years. And I believe what was really driving this was Chevron's attempt, in consort with a federal judge who I believe acted dishonestly and in corrupt collusion with an oil company, to essentially prevent me from doing my job and from leaving the country, where I was working with lawyers around the world trying to help the Ecuadorian Amazon communities enforce their judgment so they could clean up their ancestral lands, which have been so severely polluted that they were being exposed constantly to cancer-causing oil waste in their water, in their food, and in their air. So I am an example of a U.S. citizen, a U.S. lawyer, who, like so many lawyers in Turkey and the Philippines and many other countries, has been detained because of a political prosecution and weaponization of the law. Now, I want to mention one other thing. Roughly 2 years ago, my detention ended, but I'm still not free. So the other thing this judge and Chevron did is they set up all sorts of encumbrances on my life that theoretically could last for the rest of my days. Among them, I have no bank account. Chevron got a court order that I owe them millions and millions of dollars to pay them for their legal fees they used to persecute me. I have no law license. I was the first lawyer in New York denied who had his law license taken without a hearing where I could present facts that would challenge the basis of the removal of my law license. It was all an inside job by this judge and Chevron's lawyers to essentially drive me out of the legal profession. And the third thing is they took my passport. I mentioned I've been down to Ecuador probably 250 times over 20 years to work to try to help the communities down there. And I haven't even left the country for 5 years. I cannot meet my clients. I cannot leave the country to go to Canada or Australia or so many of the other countries where there are viable potential lawsuits on behalf of the Ecuadorian communities to force Chevron to comply with the Ecuador judgment. They've essentially imprisoned me indefinitely in the United States of America when I'm an international human rights lawyer. And by the way, I live under the constant daily danger of being sent back to prison or put back under detention at home because the issue of my computer is still outstanding. That is, there's still an order in this case that I turn over this information to Chevron, and the company likes that because it gives them leverage over me. And if I were to do anything that they didn't like, or that were to threaten them in terms of their financial risk or what have you out of the Ecuador judgment, they could simply ask the judge to file another criminal contempt case, again, prosecute me directly and have me detained. So, I can't really work for money. I have, by the way, a defense fund that people donate to, which is how I'm able to support myself and my family, but I can't work for money. I do work, by the way. I work my ass off all day long, but I can't work for money. I cannot travel, and I cannot be a lawyer, even though I obviously have a ton of legal skill that I try to deploy on behalf of my clients and on behalf of others with whom I consult. I cannot appear in court, and I cannot function as a lawyer anymore. And that's because we won the case, and I have been able to have, I should say, me and many others who worked on this case collectively, we've had a great deal of success. So things are perilous for me. I recognize, and I want to say this clearly, they're more perilous for many other lawyers around the world, including our friends in Turkey and, Russia and, obviously Gaza, so many other countries, that over the last 10 years, Global Witness found that I think 1,200 environmental defenders, many of them lawyers, have been murdered around the world, most in Latin America. So while I have suffered and paid a heavy price, me and my family, and I'm still paying a price, I want to acknowledge, and obviously we don't compare human rights abuses, it's futile. Every human rights abuse is wrong and needs to be corrected, but I do want to acknowledge my solidarity with those around the world, also lawyers, also campaigners, who are suffering similar, if even worse types of repression in their respective countries. I have so much respect for all of you, and we are all in solidarity with each other. Now, I want to make a couple of points about the lessons that I think we can draw from this, or some of them. Maria went through it a lot at the top of during her presentation, but I just want to say, if you take the Gaza issue away, and obviously that is the issue right now of human rights in the world, people appropriately very focused on that. But prior to October 7th, there was significant uptick in repression in this country against lawyers and advocates, particularly those who operate in the climate justice space, those trying to address issues of global warming. One of whom, a woman named Jessica Resnicek, she vandalized in an act of peaceful civil disobedience a pipeline on indigenous territory in South Dakota, in the state of South Dakota in the United States. She was sentenced for this act of property damage. And during her sentencing, the U.S. Department of Justice asked the judge to give her, she's faced a maximum sentence of 3 years in prison. The U.S. Department of Justice asked the judge to enhance the 3 years by 5 years for a total of 8 years on the grounds that she was a terrorist. All she did was vandalize a pipeline in an act of peaceful, politically motivated civil disobedience. And there are increasing number of laws being passed in the United States at the state level that designate any protester who protests at an oil installation, an oil refinery, a pipeline, even a gas station, to get a sentencing enhancement on the grounds that they are aiding domestic terrorism. On the Palestinian question, those of us in this country who question Israel, a lot of people are questioning Israel. Jews, non-Jews, people of all faiths. As my colleague explained, the whole issue of student protests in this country over Israel's civilian slaughter of Palestinians in Gaza is being exploited by Israel and its allies here to try to criminalize peaceful protest, and to try to equate peaceful protest against what many legal experts believe is a genocide with terrorism. And I see this right in my neighborhood. I mean, literally Columbia University, which is sort of the ground zero for a lot of the student protest activity that we've seen in the United States, is 10 blocks from where I'm sitting right now. And I've been up there a lot. The campus is still completely locked down and militarized. And the process that university employed to call in police to arrest its own students who were functioning peacefully is, to me, a precursor for a much more ominous movement in the United States legally to try to pin the terrorist label on those who question Israel. And it's really concerning, to say the least. Israel is trying to create a situation in the world generally, but in the United States, where they essentially run our politics. I've never seen a foreign government run the politics of the United States as regards it more than Israel. They run our politics by contributing so much money to congresspersons and for various other reasons that everyone, I'm sure, is very familiar with. But Israel right now is essentially trying to create a legal situation in the United States where any person who criticizes the country's behavior or who questions the concept of Zionism will be designated an anti-Semite, and anti-Semites then who question Israel will be designated as supporters of Hamas. That's where this is heading, and subject to anti-terrorism statutes that ultimately could lead to long terms of imprisonment. This is a massive attack on free speech. It is a massive attack on freedom of expression. And these types of human rights violations are taking place in a country that tries to claim to the world it has the greatest system of rule of law ever invented. And I can tell you, as an observer watching this, and as someone who has personally experienced the bite of the corruption that can take place in the US legal system, the truth is so much different than the myths our country tries to project to the world. So if I could leave you with one thought, it is this. What is happening here is not that different from where you're sitting right now if you're in the Philippines or Turkey or any other country where those who speak out for justice are really being targeted by the weaponization of law, as the first speaker so eloquently pointed out, to suppress speech and to criminalize human rights work. We're seeing this for those who take on the oil industry. We're seeing this, against those who question U.S. foreign policy, particularly as regards Israel. And we're seeing it also in groups of people who challenge the use by U.S. police forces, practices they use to attack communities of color. We're seeing this in Atlanta, Georgia right now, where 62 people face a bogus racketeering case that could land each of them in prison for 35 years because they challenged the construction of a police training center to train cops in urban warfare, which essentially means how to attack urban communities that challenge the power structure. So we are facing enormous challenges in the United States, like the rest of the world. I think it's important as heck we have a global framework to understand how these trends are happening in multiple countries simultaneously by various representations of the global power structure. You see this, by the way, hugely in the UK right now, where freedom of speech is being greatly curtailed. We're seeing it in the United States, obviously countries like Turkey and so many others. It's been going on a long time. All I'll say is let's connect and understand that just like there seems to be a global framework for repression, we need a global solidarity to respond to it.
Thank you so much, Stephen, for describing Chevron's retaliation against you and the ongoing unprecedented legal persecution of you in U.S. courts for the so-called crime of effectively representing your clients, the tribal communities in Ecuador, and also relating your case to worldwide weaponization of law and tying together all of the other presentations. Thank you so much for that. For the next period of time, I would like to give the panelists a chance to respond to each other's presentations or bring up additional points. We would love to hear from Sharon, Maria, and Stephen, and whatever you'd like to say, and then we will open up the discussion to the attendees. So just to fill this temporary silence, and that is that after 8 years of first a preliminary examination and then a 3-year investigation, nearly 3-year investigation of Israelis and some Hamas leaders for war crimes and crimes against humanity in the occupied Palestinian territory, and resisting pressure by Israel and the United States to not issue any arrest warrants for these people, notwithstanding the issuance 1 year after Russia's invasion of Ukraine of arrest warrants for Putin and another woman in Russia. Finally, as we were seeing genocide happen in real time before our very eyes, the prosecutor of the International Criminal Court has issued arrest warrants against Netanyahu, Gallant, and 3 prominent Hamas leaders. And the Israeli government and the US government are mounting a full court press to try to stop and interfere with that investigation that is so long overdue. So if any of you would like to respond or raise any additional points, that would be great.
Maybe you could call on one of us. We're just all so humble. We were scared to speak first.
Okay, how about Sharon? Would you like to make some comments, Sharon?
Thank you. I think I will just want to make some comments about what you said, Stephen. This is very important to mention that the situation in the United States or in the UK are very much similar with the situation in the so-called other countries. And being ignorant about this is the biggest problem that we are still dealing with. You know, there are a lot of common works that we are doing with significant number of legal organizations, but the most difficult thing is convincing them to say something about the US democracy, like against the US democracy. Or, for instance, it is easy to talk about Kurdish issue outside Turkey, but when it comes to the independence of Catalonia, then you start to receive criticism from your colleagues who are also within the human rights field. This is not the topic of today, but I think as a progressive lawyers, one of our duties is defining the human rights defenders also, or how to say, reclaiming the human rights defenders title. Because unfortunately, as it happens in many other fields, such titles, such statuses, they are also time to time captured by the mainstream ideas and their content is losing the essence. So I think what Stephen said or reminded us was very important. Thank you for this, Stephen.
Can I just respond to that real quick? Thank you for saying that. This might not surprise you, but this is crazy. So when I got hit by these acts of persecution. And by the way, I'm a white man in America, so it comes with certain privileges, okay? When I would describe this to people, like my fellow lawyers, people usually, at least initially, didn't believe me. They did not believe me. They're like, no, that can't happen in our country. There's no corporate prosecutions in the United States. I'm like, no, this happened. And of course, then they look it up and they're like, holy crap, like they couldn't believe it. But the false consciousness about the US legal system in the United States, in the legal profession, is extensive. And I'm sure it's the same, I think, in many other countries where people are like, oh my God, it's so bad in my country, at least in one place, like the United States, lawyers don't go to jail. But, just like we see globalization in economic structures, we are now seeing globalization in acts of governmental and corporate repression against critics and those who speak out. So, I appreciate what you're saying. Because of my friend, the musician Roger Waters, who has spoken out a lot about events in Turkey, I've become somewhat sensitized to what's going on in your country, and I've read about it. And I just want you to know, to all the lawyers in your country and campaigners, so many of whom were in prison without charges. I mean, there were indefinite sentences, years and years and years. I just want you to know how we know about that. okay, number one. And number two, how much we admire the courage of lawyers in Turkey who were standing up to the Erdogan regime to the point where they were literally losing their lives, being killed, or being incarcerated without charges in violation of law for years and years and years. So thank you for saying that. And I hope someday, if I can ever get my passport back, to meet you in person and somehow collaborate on something.
Yeah, thank you. Thank you.
Maria, comments?
Yeah, I'd like to also thank my co-panelists. You know, listening to everyone, you're always reminded how similar the tactics are around the world and how you can see what's coming next in some places or look behind in others. And it's, you know, Sharon, I've followed the attacks on lawyers in Turkey, and Stephen, you know, I'm familiar with what's happened to you, but sitting here today, I am still shocked. You know, I hear it again and I'm shocked.
I know.
It's
I
almost it's too much to hold in your mind or your heart all at once. And I think it's true, in order to fight it, we somehow need to, I don't know, condense it or unite forces better globally. And Stephen, I also appreciate you broadening out the suppression in the US against different social movements. And I was thinking, you know, I had mentioned in mine, you know, white supremacy, but capitalism.
Yeah.
You know, if you're fighting against capitalism, you're also, you know, a terrorist. So it's really about challenging power and how do we do that successfully, and how do we protect those who are doing it?
And how we control language.
Yeah.
You know, because when
absolutely.
they say we're terrorists, we're not. We're human rights defenders, or whatever you want to call it.
Yeah.
They are the ones weaponizing terrorism to violate the law. So we always have to, I think, correct some of the frameworks that people just assume exist, including those on the progressive left. You know, we get by default, we sort of get trapped in these frameworks that give the advantage to those doing the oppressing, you know. So I think the issue of language and how to describe what's happening is really, really important. I mean, you pointed out about how to define anti-Semitism. I mean, oh my God, I'm Jewish, okay? I'm very sensitive to anti-Semitism, but I can tell you that the anti-Semitism, which is being used as a pretext to violate free speech of peaceful pro-Palestinian protesters, is BS. It either, you know, there's real anti-Semitism, and then there's this manufactured myth of it being widespread, which it isn't in the United States, which is then being used to go after pro-Palestinian protesters. So how to understand that and understand what anti-Semitism is and is not.
Right.
How it is being weaponized is really, really part of the job now of lawyers and advocates. We have to start with just being really clear about what's what.
Yeah. And the narrative, shifting the narrative is a battle into itself. And it does seem more and more, you know, in the past 6 months, that it's an upside down world. The truth has no meaning. And I don't know if this is, you know, I don't think it started with Trump, but I think back to the Iraq War. I think back to post 9/11, and yes, there were lies proliferating, but now it feels like everything is a lie all the time, and nobody's calling anyone out.
No one even, But I'll tell you this. I'm going to give you an example of what you're talking about, if I may. So when Chevron sued me in 2011 for $60 billion, they got a major U.S. newspaper, the Wall Street Journal, to write an editorial about me called Amazon Swindle. They basically accused me of working on this case for 18 years because out of greed, and I was actually trying to use the case to extort money out of Chevron. That's what that was their theory. And the Wall Street Journal wrote this up. And at that time, I'd worked 18 years on the case. I thought I was a good guy. You know, I was getting respect from my colleagues, my clients. I enjoyed my work. And suddenly, like literally overnight, they got the media to attack me. And many people who were colleagues of mine didn't want to have anything to do with me, like overnight. It was crazy, like abandon their friendships with me because they were so scared. And my wife looked at me. I've been married I got married in 2006. My wife, Laura Miller, you know, great woman. She's like, do you think you'll ever get your name back? She asked me that. And I just want everyone to know that I didn't realize how much I depended on people respecting me for my own self-esteem until that moment hit when people didn't really respect me anymore. And I told her, I said, I don't know if we'll ever get my name back. Because I mean, at that point, it just seemed impossible. You know, they had literally millions and millions of dollars. I had nothing. They could buy paid media. I mean, I felt like it was just over. My professional life was over. And I told my wife, I said, one thing we can do is at least keep our narrative, our truth alive. So there's two narratives. And if people Google it or look it up, they'll be like, well, Chevron says this, he says that. I mean, at least we could do that, which is what we did. And the crazy part is over time, over the next 10, 12 years now, little by little, when we explain this to people and they locked me up and people paid attention to it, and my social media presence grew a bit. And I got invited onto panels like this, and the IADL wrote a report about my case, and the National Lawyers Guild came to help me, and the Center for Constitutional Rights came to help me, okay? Little by little, people of influence and intelligence began to realize that what I was saying about what was happening to me was actually the truth. And I have come back to some degree, you know, I mean, if you Google Chevron, I'm still a criminal. But the reality is, I would say most people who are familiar with my situation believe in me. And I never thought back in 2012, when my wife asked me that question, I would be able to come back this much, and that I would be able to have people like Maria and Sharon and Marjorie and Jeannie Mirror and Natalie Segovia and so many other prominent progressive lawyers in the world and in the United States understand the truth. I never thought I'd see the day. So I don't know what I'm trying to say with this story, except that it is critical we never give up and we keep organizing, struggling, and telling our stories and telling our truths to as many people as possible through as many platforms as possible, because you know what? Anything is possible. Like, we can win these cases. We can win these battles, even though when it looks bleak. Why does it look so bleak? They're desperate to maintain a power structure that's not working for the vast majority of people around the world. So they commit genocide, or they lock a guy like me up, or they go after lawyers in Turkey. You know, they're the ones who are feeling the heat, which is why these acts of repression, in my opinion, are occurring with greater frequency. So what does that mean? You know, I don't know. I think there's an opportunity in understanding that maybe we are closer to a great deal of success than we realize. You know, half the battle, I'm telling you, they want us to believe we can't do this. It's psychological. They wanted to lock me up, so I would think I'm just going to give up. Give up. You know, they want to convince us we can't do this work successfully. And what I'm really trying to say is we are doing it successfully, which is why these acts of oppression are happening with such frequency. Sorry I went on so long.
I wanted to throw something out that came up in the chat, and that is the issue of the effectiveness or lack of effectiveness of the UN. Certainly, we know that the US paralyzes the Security Council by providing diplomatic and political cover anytime Israel is criticized in the least. But I am afraid that people conflate the Security Council and what it does or doesn't do with the United Nations. The United Nations is much bigger than just the Security Council. There is the General Assembly, which is really the people's body. It's not constrained by permanent members and vetoes. One country, one vote. And the General Assembly has taken some very, very significant actions. The UN special rapporteurs who have spoken out and written reports that have been devastating to human rights violators, particularly in Israel. And so if any of you would like to comment on any of those things. And Stephen, I don't know if any UN body did a report on your case, arbitrary detention, any working groups.
They did, and I have some thoughts on that, but I'll defer to my colleagues and maybe follow up.
Why don't you go ahead and respond to that?
So the United Nations, I mean, like everything, it's a mixed bag, right? But like, you know, it is the one global institution theoretically dedicated to peace and the prevention of war. The fact that it has continually fallen short in achieving that is one thing, but you know what? It has actually helped in a number of ways across a number of conflicts. And like, for example, if you just look at all the human rights bodies that exist within the United Nations structure, there's a lot of possibility there to do really good accountability work, human rights work, and political work that can help a lot of people. And I saw this personally because the Working Group on Arbitrary Detention of the United Nations Human Rights Council did an entire report on my detention, and they found it to be arbitrary, illegal, violation of international law, multiple provisions of international law. They presented their findings to the US government under the Biden administration, which completely ignored this report. They actually they requested, because they can't order, that the US government release me immediately, investigate how this could have happened so it doesn't happen again, and pay me monetary compensation for the arbitrary deprivation of my liberty, which I would calculate mathematically as X number of dollars per day that they should pay me. And I've lost so much income, and I have no money, just so people know. I live off my defense fund. I have no bank account, okay? So, but interestingly, the US government, and we see this now frequently, regularly with Israel, believes itself to be above international law. But the UN is a institution that at least does have some degree of independence, so it doesn't completely bend itself to the wishes of the United States or Israel. That's a good thing, even though obviously if it was structured differently, if the United States didn't have a veto, which I really think that's deeply unfair. It's sort of the international version of the US Electoral College, you know, where certain small states essentially have veto power over who can be president of the United States, you know. So they help me a lot, but you know, what can we do? I mean, I think that you mentioned the ICC arrest warrants, the ICC, the ICJ, probably two of the world's most prestigious courts right now are on to Israel's BS. They're on to Israel's human rights violations. And that's a good thing. Is it perfect? No. You know, why the ICC take so long when it moved in 1 or 2 weeks against Putin, but took, 8 months to move against Israel? Why did they indict or issue warrants for 3 Hamas leaders and only 2 Israelis? What's that all about? But it is happening to some degree. And I think that is a response to the work we do as people, the political organizing, the accountability work that Palestinians have done by documenting the atrocities with their phones and putting them out to the world on social media. I mean, this is the first time I can remember where the victims of mass human rights atrocities are actually the investigators that are creating the evidence that will be used against the perpetrators. So there's a lot of extraordinary things happening. We have to obviously be balanced in our assessments of the good, the bad, the ugly. But there are some things moving forward that I've never seen before that are positive. And I think we ought to understand what those are and try to keep pushing forward with those things.
Maria, you touched on BDS, boycott, divestment, and sanctions, which of course is a nonviolent initiative of Palestinian society calling for boycott, divestment, and sanctions until Israel complies with international law, ends its occupation, protects the human rights of Palestinians, and permits the return of refugees as required by the General Assembly. The effectiveness of the BDS movement led Netanyahu a few years ago to call BDS an existential threat to Israel. I think the other existential threat he identified is Iran. So he's got BDS right up there with Iran. And it's not a coincidence that the students who are encamping and protesting and marching and demonstrating all over this country, I think Maria said more than 180 campuses, are calling for not just an immediate ceasefire, but divestment of their campuses from the Israeli economy, basically. And before we saw this ongoing genocide's been happening, but the stepped up genocide in Gaza, there has been an ongoing attack against BDS in the United States, where both the federal government and many state governments, probably most state governments, are criminalizing boycotts in violation of the First Amendment. There's nothing more American than boycotts. This country was built on the boycotts during the civil rights movement, the farm worker boycotts, the grape boycotts, the lettuce boycotts, and certainly worldwide, the boycott of South Africa that led to the dismantling of apartheid in South Africa, along with the valiant struggle of the African National Congress and its allies. So does anyone want to comment on this repression against BDS movement? Maybe Maria, some of these anti-boycott laws. I don't know if CCR has had experience with those. I thought that might be something that people might want to comment on.
Yeah, I did mention the anti-BDS laws. I want to be clear so as not to cause any more chill. There's not, it is not criminal to boycott in the United States. It is protected First Amendment activity. There are the laws in states that prevent a state from investing in an entity, and some that prohibit a state from contracting with a person or entity, which are being challenged, as I mentioned. There has been federal legislation considered that would actually criminalize it. That has not been passed and would certainly be challenged on First Amendment grounds. But you're absolutely right. Students are protesting. They're seeking divestment. There are divestment votes coming up in universities. I feel like this is the beginning of the end, and Israel knows that. This is what brought down South African apartheid. The students are on it. The universities will follow, and eventually Israel will be isolated and won't be able to continue the occupation, apartheid, certainly the genocide. So yeah, I think it's really about withdrawing our complicity in this, the rotten endeavor that Israel is at this point. And I think, yes, there will be lawsuits challenging divestment. Yes, there will be lots of things. But as Stephen said, the people are courageous and will keep pushing forward. And it's part of the fight. It is part of the struggle, pushing it back against this oppression.
There is a question in the Q&A box. To what extent can the International Criminal Court withstand pressure from the US and Israel? And to what extent does the Assembly of States Parties, which is the group of parties to the Rome Statute for the International Criminal Court, to what extent does the Assembly of States Parties influence the ICC, the court's approach toward Israel from a diplomatic and political standpoint? Anybody want to comment on that?
So I just want to say a couple of observations about the International Court of Justice case, the genocide case brought by South Africa. I want to say that the quality of lawyering in these cases really matters. And I've seen this with CCR's work over the years. You guys do such incredible lawyering, great work, just super meticulous research and, framing of arguments. And I just want to salute the lawyers on the South African legal team, because if you read their initial lawsuit against Israel alleging genocide, it's just an extraordinary document, one of the greatest documents I've ever seen in the law, 80-something pages, just beautifully written, laid out, the whole argument. And I just want everyone to know that I happen to know that lawsuit originated by certain individuals, who saw what was happening, coming together and pulling a bunch of information together and taking it to South Africa to get it going. What I'm trying to say is people can make shit happen, individuals can really make stuff happen. And I also want to say that this is just not a normal court. There are 15 judges, including, at the time this case was filed, the chief judge was from the United States of America. And that court voted almost unanimously in the initial decision where they issued provisional orders to Israel not to commit acts of genocide. I think it was 15-2 or even 16-1, because the Israeli justice on some of the issues voted with the majority against his own country. It was so bad. The evidence was so overwhelming. That really is an incredible rebuke, isn't it, of Israel, these prominent judges from all over the world. And I want to say, those of us who live in the United States, I don't know what it's like in Turkey, probably a little different in terms of the media environment, but it is really hard to get comprehensive coverage of what's going on with the International Court of Justice. The US media either ignores it or downplays it, trying to message our population that the work is not that important. But it is. So I'm just super proud of courts. I mean, I'm not under any illusion. I'm sure my colleagues are not under any illusion that the law in and of itself will solve these problems. It won't, but it can help. It can help. And when courts make decisions like this, when they agree to take this case, it can really help with human rights accountability and ultimately help save lives. Think about it. International Court of Justice has taken a case alleging genocide against Israel and will have a trial about it, probably next year. That will last months, even years. Israel is going to be on trial. Israel, the country that supposedly was birthed in response to a Holocaust, a genocide against Jews, is now going to be on trial before the world's most prestigious court for genocide. And you know, when the militarized phase of this so-called conflict in Gaza ends, there is going to be a trial where South Africa will present meticulous evidence of what really happened there from beginning to end. And I just don't know how Israel gets out of that. You know, I agree with Maria. I think we're at a point where it's going to be very difficult for Israel to keep going as it's currently constituted. It is going to have to become a real democracy to survive, in my opinion. But I'm not saying it's going to happen soon. I mean, the resilience of these entities is powerful. They have a lot of money and power, but we do too, the people. And the people, the Gazans, the Palestinians, and their allies are pushing this forward. And I think it has a lot more success than anyone really expected, including the ICC arrest warrant. Same thing. Even though it's deeply imperfect, it's happening. So we need to keep working with these institutions and putting pressure on them to do their jobs as they're designed to do, and not be beaten back by the United States government, the Israeli government, and its allies. We have to be that unbreakable, unstoppable force as people. You know, as governments like Turkey, one good thing Erdogan has done is he's really behind this case and behind holding Israel accountable. You know, so there's elements out there that are powerful, that are on our side on this issue, and we just need to keep pushing and know we really can win this thing. I agree with Maria.
And I absolutely agree. I mean, the ICJ proceedings have been amazing, and there's, you know, they're coming out, well, their decision on more recent provisional measures is coming out tomorrow. And yes, as imperfect as the ICC has been, this wasn't a foregone conclusion that this was going to happen with either the ICJ or the ICC. So these are victories in the fight of international law against power, and they're going to continue to be fights. It's not a done deal, obviously. And I don't know if people know, you know, CR also sued Biden, Blinken, and Austin in the US federal court for failing to prevent genocide and for complicity in genocide on behalf of Palestinians, Palestinian Americans, Palestinian organizations. We had a preliminary injunction hearing where our clients testified. You know, we brought claims under customary international law as codified by the Genocide Convention. And the federal court found a plausible case of genocide, just like the ICJ did, and implored defendants being Biden, Blinken, and Austin, to examine their unflagging support for Israel. Unfortunately, it found it lacked jurisdiction, wrongly interpreting our claims to raise political rather than legal questions, primarily relying on our case in Corey versus Caterpillar. You know, basically, you defer to the US, to the executive in foreign affairs matters, which obviously cannot be the law. We've appealed it, and our appeal is being heard in the Ninth Circuit on June 10th, and will be live streamed if people want to tune in.
That is really important. I need to push that out. I didn't realize that. But you know, what you're really saying is there's a whole area of the law that they're trying to eliminate from the legal system. Like any case that challenges US government foreign policy, they're trying to say you can't bring that case. We're going to carve out those cases from the rule of law, and you just can't use the legal system to bring those cases. Isn't that the implications of
yes, utter impunity for executive decision making that impacts foreign affairs.
Just to follow up on that, CCR has done tremendous work on that case, and it was also live streamed to a huge number of people, I think 1,000 people, and really bringing a lawsuit against President Bush, Secretary of State Blinken, and Secretary of Defense Austin. And the judge, who bent over backwards to allow the Palestinian witnesses to testify and say how moved he was, and in quoting the ICJ's decision on a plausible case of genocide, said, "But my hands are tied, the political question doctrine." Well, there's no way on earth that people should be able to commit genocide, and the courts have no role in that because it's a political question reserved to the executive and legislative branches. It doesn't even pass the straight face test. And hopefully the Ninth Circuit will come to that conclusion. Sharon, did you want to say something? I'm sorry.
I think Stephen and Maria covered everything about the ongoing case, but I just want to say, like, what we learned in Turkey in history, like, the cases will never and ever, depending on the effort of the lawyers, if the case is completely politically motivated, let's say. And it's not just about the criminal cases, this is how we are organizing trainings with the workers. When they ask us to do, we say that yes, like, if you want to occupy the factory, it is written in the criminal law and it is a crime, it's an offense. But if you do it collectively, if you can also convince all the neighborhood to support you, and if you can insist on doing this, then probably the case will be dismissed because they will not be able to go on. So I think everything, like, I think the law itself, the regulation and the courts, they are all political. So I am also hopeful, but I'm hopeful because of the movements around the world, the pressure that the people are doing. I know today we mentioned some European countries' positions, but now when I am looking the news concerning Germany, I am not afraid. I am annoyed, of course, because of the state position, but I'm also hopeful because there are still students there. There are still people there who are trying to stand up, even though they are under a huge pressure, even though, there are a lot of outcomes and they're also paying some prices. So I think this is the part where I prefer to focus on. And just like an answer to you, Stephen, this was the same in Turkey. The court case was live streamed only by the state television without the translation. And the only translation was provided by the Progressive Lawyers Association through social media, like through Twitter. We just publish it minute by minute, but no, like the mainstream media, etc., they didn't do anything. And whenever the students from different political backgrounds came together in Turkey and asked for Turkey to stop any kind of commercial activities with the Israel state, and afterwards, when they were arrested really very harshly, like beaten and tortured, then the public reacted. And the Minister of the International Affair, first time after years, felt the pressure to make a statement and try to explain that no, we are not doing it. It's like it changed already. Now, the limit of the commercial activities are like very less, etc., etc. So after years, they really felt the necessity to make a statement. But yeah, like, we also didn't have the chance to follow the Turkish and Kurdish population. They couldn't follow the court.
That's interesting. I just want to ask you a question. Is the Turkish government in solidarity with the International Court of Justice role in doing this genocide case?
Recently, Turkey announced that they will support the South African case, like application, but it is quite hypocritical, So this is another political move that they prefer to do.
It's a way to give coverage to domestic repression, basically.
Yeah, this is the outcome of the domestic pressure.
I did want to add, I think somebody might have mentioned it in the chat, that Nicaragua also brought a case against Germany in the ICJ for aiding and abetting, for complicity in Israel's genocide by providing weapons, by cutting off funding to UNRWA. And they asked for provisional measures, such as the provisional measures that the ICJ imposed against Israel in the South Africa case. The ICJ declined to issue provisional measures, saying that Germany was already cutting back on its weapon sales to Israel, and Germany was providing aid now to UNRWA. But that is not the end of that case, because now it will proceed on the merits, which might take a few years, but that case is also ongoing, and there are a number of countries that have signed on to South Africa's case. So the proceedings in the ICJ are continuing. As Maria said, there is a new request by South Africa for provisional measures to keep Israel from going in and slaughtering and ethnically cleansing Rafah. They've already displaced 1 million people in 2 weeks from Rafah. And notwithstanding Biden's very meek, well, you shouldn't do that, but we're still going to give you billions of dollars in weapons. It's very significant that these cases are out there in the public realm, and particularly the ICC case as well, after so long with no action at all. In terms of the ICC's case investigating Taliban and Afghan and US leaders for war crimes and crimes against humanity during the Afghan war, when the new prosecutor came in, Karim Khan, he said, well, we're not really going to investigate US leaders, just Afghan leaders, just Taliban leaders, clearly succumbing to pressure by the United States. But it's very significant that in today's New York Times,
Yeah,
at least
that's his investigation right there.
In the hard copy, which I get today, it's on the front page and goes into several pages on the inside with pictures and photographs and documentation of the torture and the war crimes committed, not just by the Turkish authorities, not just by the Taliban, but by US authorities. Hopefully that will spur the ICC prosecutor, who has already been somewhat emboldened by the ongoing genocide and mass movement against it, to do something about Israel, will add the US leaders back into its investigation of war crimes and crimes against humanity during the Afghan war.
I wanted to throw out a question, Marjorie, to you and my fellow panelists. I'm curious if anyone could chew on this. And I don't know if we have time to do this. I don't know if you.
Sure, go right ahead. Yes.
So my question is, does anyone expect a country to file a lawsuit against the United States for its role in financing this alleged genocide before the ICJ, similar to what Nicaragua did with Germany?
Yes, and I was wondering about that same thing. I mean, certainly we saw South Africa suing Israel. South Africa did not sue the United States, and the United States is a party to the Genocide Convention. The United States is bound by ICJ rulings. The United States, of course, is not a party to the ICC, because even though Clinton put the US signature on the statute, George W. Bush unsigned it. But I don't know. So we're talking about individuals. The International Criminal Court is a criminal tribunal. It doesn't bring lawsuits against countries. It brings lawsuits against individuals, such as Netanyahu, Gallant, the 3 leaders of Hamas, etc. And likewise, the CCR lawsuit on behalf of the Palestinians and Palestinian human rights organizations are suing individuals. Biden, Blinken, and Austin. But there has not been a lawsuit filed against the United States for aiding and abetting genocide in the ICJ, and that certainly should happen. I don't quite know why that hasn't happened. South Africa could have included the U.S. government for aiding and abetting, or for complicity, but did not do that.
I mean, I think there's a couple reasons. There's, the US has not subjected itself to the jurisdiction of the ICJ for that, even though they've come in on other things and weighed in, of course, in different situations. Also, it takes a very courageous country to go up against the US. I mean, this is where really the international law and power meet each other. I mean, but under the law, absolutely. There's a case, and it's a case that we've made. The US is no doubt complicit in aiding and abetting this genocide. And as far as the ICC goes, yes, absolutely. There could be criminal charges against high-level US officials because it's taken place in the territory of Palestine. Will Karim Khan do that? Maybe someday.
Yes, just to clarify and follow up on what Maria said, even though the United States and Israel are not parties to the Rome Statute for the International Criminal Court, Palestine is. And therefore, any crimes that take place in the territory of Palestine can be the subject of there can be criminal prosecutions of foreign nationals such as Biden, Blinken, Austin, etc., for aiding and abetting genocide in Gaza. Now, also, there's another thing that hasn't been mentioned, and that is that the arrest warrants that are being sought by the ICC, the International Criminal Court, against Netanyahu, Gallant, and the 3 Hamas leaders, charge them with war crimes and crimes against humanity. Now, the Rome Statute also includes genocide. For some reason, and I don't know why, and it may be that it was a compromise decision. They were advised by a panel of experts, including Amal Clooney and others. Maybe it was a political compromise not to include genocide, but certainly the elements of genocide have been more than met. We saw that in the ICJ case, and yet the arrest warrants are for war crimes and crimes against humanity, which I'm not belittling. I'm just saying they should also be for genocide as well. If there's, yeah, go ahead, Maria.
No, yeah, I don't know if it was a compromise or just a political, strategic decision, but just to reiterate that extermination is one of the crimes against humanity, and so is persecution. And really together that equals genocide. Exterminating based on a discriminatory purpose, and crimes against humanity obviously are widespread and systematic. So even though it's not named, it is obviously named by the ICJ. It's still quite something.
Right.
And and this is, you think about the freedom for these men to travel will be impeded, hopefully at some point. This is, again, the prosecutor requested the arrest warrants. Hopefully the court will issue them. There's also the opportunity for universal jurisdiction for people to be sued in other countries. There are lots of avenues for justice and accountability, and we need to just keep pushing on all of them.
There has been a mention in the comments about Julian Assange's case, and I think we would be remiss if we didn't talk about that. Julian Assange, of course, is a publisher who is a co-founder of WikiLeaks, and in 2010 and 2011 published evidence of US war crimes in Iraq and Afghanistan and Guantanamo Bay, based upon documents that Chelsea Manning had leaked. The Obama administration, which prosecuted more whistleblowers than all prior presidents combined, convened a secret grand jury and decided not to indict Julian Assange because of the so-called New York Times problem. And that is that WikiLeaks did exactly what the New York Times and Der Spiegel and Le Monde and The Guardian, etc. did, which was to publish classified information. So they didn't indict him. Along comes the Trump administration. They had no qualms at all about indicting Julian Assange, and he is facing 175 years in prison for charges under the Espionage Act, 170 under the Espionage Act, for revealing evidence of US war crimes. And this has been a long saga. He has been locked up for 5 years in Belmarsh Prison in London, a high security prison. He's in very frail mental and physical health. He has been appealing. He has not had much luck with the High Court of the UK, of England and Wales. But just Monday, there was a very significant decision by 2 judges on the High Court to allow Julian Assange to appeal 2 issues. One, that he would, if he were extradited to the United States to stand trial, that his First Amendment rights would be violated because he would not necessarily be able to use a defense of freedom of expression, which is protected under the European Court of Human Rights. And secondly, that as a foreign national, he would be discriminated against because foreign nationals do not necessarily have First Amendment protection in the United States. On Friday, tomorrow, there is going to be a filing by both sides to try to set forth an outline for the hearing, the appeals hearing. The case is still alive. Meanwhile, Julian Assange continues to languish in prison, and the ramifications for investigative journalism and national security journalism and people who reveal government wrongdoing are significant here, because if Julian Assange is extradited to the United States and tried and convicted under the Espionage Act, it will chill the willingness of journalists to report government wrongdoing. So it's a very, very significant case. Julian Assange certainly would fit into the category of human rights defenders, and I think that it's important to mention that. I'm just looking.
I-
Go ahead.
Are there questions from the audience?
Why don't you go ahead and comment on that and I'll look at the
I
questions.
was going to say, I think the Assange case, wow. I mean, my analysis of what's going on there is it's a total test of wills between freedom to be a journalist and those of us who understand that is world public opinion, and the U.S. national security state that wants to destroy this man because he exposed them for being war criminals. Okay, it's really simple. They can't handle the fact that Julian figured out a way to do what journalists have done since time immemorial, which is to get documents that expose wrongdoing. And his mistreatment over the years, he's now been detained for 12 years. Last 5 years in the Guantanamo of the UK, Belmarsh prison, is appalling. I mean, I actually believe their strategy is to induce his death. That's what I think they're trying to do. They don't want him to continue living. So, you know, he's been amazing in terms of what he's had to put up with. I do feel sort of like with the ICJ, there's a bit of a shift in favor of justice in that case. You know, Biden said he was considering maybe sending him back to Australia. He's Australian. We got to keep pushing. You know, it's about Julian, it's about his family, it's about justice, and it's about press freedom. So I relate to him. I mean, I relate to what he's dealing with. And I have to, I mean, obviously what he's dealing with is just, it's hard to get your arms around, but you know, we need to care about Julian and not forget him. And by the way, I just want to mention this. There's the former UN Special Rapporteur on Torture is a man named Nils Melzer, Melzer. And he wrote the most incredible book about Julian. I think it's called The Trial of Julian Assange. He doesn't know him. He investigated the entire case in his role as the UN Special Rapporteur, and he explains everything. Anyone out there has questions about Julian's character or the supposed issues he had in Sweden, it's all BS. It's all BS. Nils investigated that whole thing. This is a direct assault on a man who spoke truth to power, and it's an attempt to really, induce his death, in my opinion, from the United States government. So we have the power to, I think, get him free in the near term. And I'll also mention the Australian government now has adopted the official position that they want him out. That's big, because that's obviously a key ally of the United States.
Thank you for that, Steve. There's an important question in the chat that each one of you or any of you should feel free to respond to, and that is, as a young attorney looking to get involved in human rights and movement lawyering work, could the panelists please speak about how they got into the work that they currently do? Could the panelists also speak a bit about what they recommend young attorneys like us do to get involved in such work? Anybody want to take a crack at that?
I think, oh, go ahead, Susan.
No, you go.
No, I started off almost 30 years ago as a lawyer, and I was doing housing work and employment discrimination and police misconduct. And that's all human rights work, even if it's not international. You know, the local work is extremely important too. And you can always incorporate human rights narratives and norms and mechanisms into whatever work you're doing. If you are interested, Palestine Legal has an attorney network. There is a huge need to face the suppression against Palestinian rights activists right now, as I mentioned. So you can always sign up on their website to be part of the network. If there's anything you can do wherever you live, you can, it's just for defending students in disciplinary actions, for example. It really takes paying attention and knowing your stuff, and it's not necessarily a particular skill. Obviously, other cases require some experience maybe, but I would say, whatever you're interested in, follow that path, and you can always, really be a movement lawyer in various ways and support the communities you're in.
Steve, did you want to chime in?
I was just a couple of thoughts on that. I mean, I'm an example of a lawyer who ended up in this situation fighting for human rights organically. Like, I didn't start my career thinking I want to be this guy I've become. Okay. And I think if you're committed to human rights, and I'll build on what Maria said, there's so many human rights issues right before your eyes in your own community. Police brutality. By the way, these are human rights issues, and they do have international implications, even though they might be based in your community. And there's so much need for legal representation start taking some of this stuff on a very small level and see where it goes. The most important thing is you want to do the work. You like doing the work. I would bet that Saron and Maria would agree with me that, like, as difficult as the challenges are, like, I like the work. Like, I enjoy my work. I recognize we're dealing with massive crimes and tragedies all the time, which I hate to see exist, but the work itself that is trying to make the world a better place is a wonderful mission to define one's life. By the way, I'm not necessarily saying I've been so successful at it. You know, I don't even know. I don't even care. But I don't do this work out of altruism. I do it because I like it. So my advice to young lawyers is start doing the work at whatever level you can do it at. And even if you have a job that pays you that's not a human rights job, you can still maybe do some pro bono work to get going and see where it takes you. You know, it's people who do work they care about tend to be much more successful professionally than those who just work for money. I want to be clear about that.
Sharon,
think
did
I
you
just
want
want
to chime
to-
in? Yes,
yes.
go ahead.
I just want to add something because I think like two aspects were covered already, but like for myself also, it was not a choice. And in Turkey, you know, like I tried to mention this before, but I will just highlight this. The human rights lawyer is a new concept. Like we were calling, like, and we are still calling ourselves as people's lawyer. And we, like, some of us call ourselves as the politically engaged lawyers. Some colleagues can call them the lawyers who are supporting revolution, so they can call themselves as revolutionary lawyers. So I agree with Maria, human rights field is huge. And there are a lot of violations around the world. And just by walking in the street, you will observe inequality, poverty, violence, etc. You don't need to focus on the big picture, but I think the details are important because there are a lot of vulnerable groups who need the support from the people, forget about the term of lawyer, people who has the tool of knowledge here, which can be time to time abused in favor of the vulnerable, which can be, you know, used as a tool of struggle. So this, like, I think since you have the awareness, then you can find the field. And additional point to Stephen, like Stephen mentioned, the pro bono part, but I believe that the most important way of doing this thing is being a part of a collective. If
Yeah.
there is an organization in your country, in your city, a progressive one, a legal organization, or not a legal organization, but an organization that you think which is doing an important work, but you can, like, and you can support with your knowledge, then just go and work there, you know, because we all have free times. Like after engaging with the work, you will not have a lot of free time. But you know, I hope that now you have, and just invest this time to the work of the collective, because this way, I think it's the best way. Like you learn and you also teach, you know, it's kind of a process which is more proactive and interactive. So being organized is one of the most important issue in this field.
One of the
If you
questions.
do so, then you will say like, very sorry, one more, like, you know, he's not really successful time to time. And this is also something, you know, when you are part of a collective and you lose, you can still go on. You know, this gives you the courage
Yeah.
and the energy because you see that like the others are fighting with you and you are not alone. Yeah.
I think can I just second that? That's so important what you just said. So important. I think if there's one mistake I might have made and why I was a bit vulnerable is because I was working alone with other people, but we weren't like in a collective. We were all working individually in coordination. But what you're talking about is a real legal structure with, say, 10 lawyers, 30 lawyers. And they know the Chevrons of the world or any government's going to know if they go after your collective, they're going to be hit with 30 lawyers, not just one lawyer. So I think that's a wonderful organizational structure for young lawyers to think about.
Yes, and just one final thing there. Someone asks, how do you deal with how much the judges and prosecutors hate you when you're representing your person? Maybe international human rights lawyers could start mentoring. And I think that what Sharon said is an answer to that question, and that is it's really important to join collectively with other human rights lawyers who are doing the same thing, that especially people like CCR And the National Lawyers Guild is also an important resource. I would urge you to go to nlg.org and get involved in the National Lawyers Guild. We have a mass defense committee. We have lots of different committees, immigration committee, racism committee, etc., anti-racism committee that you can use to network with like-minded people who want to and are defending people's human rights. And also, this is probably the last comment, and that is we're hoping that the People's Academy of International Law can provide a mechanism for networking among human rights defenders, among progressive lawyers, activists, legal workers, etc. So feel free. I know time is short here, but in future programs, to put your contact information into the chat. People can get in touch with you. This has been an excellent program. And thank you to our faculty, Edre, Sharon, Maria, and Stephen for your excellent presentations, to Charlotte Cates for making it all happen, to the interpreters, and all the people who attended this course. Our next program of the People's Academy of International Law will take place on Thursday, June 6th at same time, 9:00 a.m. Pacific, 12:00 p.m. Eastern, and it will be course 4B, the second part of the criminalization of rights and human rights defenders as a means of repression. And the faculty for that course will include Natalie Segovia. She is very active in the National Lawyers Guild and was instrumental in the Water Protectors Collective. Galo Chiriboga Zambrano, who was the Attorney General in the in the Correa administration in Ecuador, before the current administration, which is very repressive. And Jong Uk Kung from South Korea, who has worked tirelessly against the national security law there. And Jeffrey Frank from the National Lawyers Guild, who works with landless Brazilian peasants. So once again, that will be Thursday, June 6th, same time. We will be sending out notices in the near future, and we thank you so much for attending this important program. Upward and onward.